I don't have a clip about this, but Adams also got into the part about Woody's cell phone data and Lil D's cell phone data, right? Yes, please like and subscribe to the video. Like the video, please. Adams was letting it be known, hey, Woody gave you an alibi and said that he was on the phone with Lil D, and there was a phone call between him and Lil D's phone. Yet, that's the same exact time that he also said he was in the car with Lil D. Because y'all remember that he said like Lil D came and picked me up, and then Nard got in the car and he stopped talking, whatever that was. Adams brought that up. Adams said, hey, did you realize that the time that he said he was in the car with Lil D, these two people were supposedly, like the phone records say that they were on the phone with each other, right? And, you know, that one of the few clips later on, we could talk about that, right? But the phone data does not match up with what's going on here, right? So I think Adams did a great job on his initial cross. Then Shark comes up next. He's also talking about this bad investigation that they did. And this is before Gaither even comes back. Shark is going at Sprinkle about files being missing, right? Yo, there's missing files. There's missing reports. What's going on? There's missing video. Just a whole bunch of stuff that's not really making sense, right? But Shark didn't take too long also either. Weinstein comes up next. Weinstein wanted to establish that Sprinkle is really, you're not an expert in any of this. You're not an expert in cell data. You're not an expert in reading phone records. That's not what you do, right? You're not an expert. And Weinstein just had to establish that because the jury might get confused and think because he's a prosecutor that he has some higher level of knowledge of any of the stuff going on. Weinstein is like, you're just a regular person talking about cell phone data. You're not an expert at all, right? So Weinstein did his part, right? So Love comes back on redirect, right? We're going to talk about that, K-Way. Love is back on redirect, right? So I guess they approached the judge and the defense had an objection about a picture, like an Instagram picture that they was going to put in front of the jury. The defense said, hey, judge, that's a hearsay objection. And Love said, like she does, hey, judge, we're not providing this for the truth of the matter asserted. This is for effect on listener. We just want to know what Sprinkle did when he saw it. Right? That whole thing. We've heard that. I didn't hear this conversation, but we heard Love do this so many times. We already know what she said up at the bench. This is not for the truth of the matter asserted. This is for effect on the listener, right? Pretty much what did this person do when they saw it? That's what that means, right? So the judge overruled the defense's objection to showing this Instagram post, right? So Love gets in front of the jury and very early, and what was going on? Love puts this picture in front of the jury. And then this is literally the first thing she did when the picture came on the screen was say, now, if you look at this phone number here, what she pretty much was like whose name is that right next to that phone number? Adams got up and objected. This is where really like all hell is breaking loose at this point. This is where all the clips going viral. You got this. There's everybody in the world talking about the trial on Monday. Even Joe Budden and them was talking about it on Wednesday. They never talk about this trial. When she showed that Instagram picture and asked Mike Sprinkle, whose name is that next to that phone number right there? Even Judge Whitaker was baffled. Like, you just told me that wasn't what you was doing this for. She was really like, you could tell Whitaker was just baffled that Love literally just said that and then literally did something exact opposite. Man, we got clips, man. We got clips, y'all. Let's get to the clips. Let's get right to the clips because we ain't got no time to waste. I want to hear it from the beginning.
The number is next to.
I would renew my objection and also object on the basis of hearsay if he's reading from a document.
The number is next to.
I would renew my objection and also object on.
Okay, so I started recording a little bit too late. She said, what handle is that number next to, right? They have already established that whole comment section is hearsay. But Love told them, I'm not using the comment section. I just want to ask him what he did when he saw the post. And then the first question was, whose name is that right next to that phone number? Right? So this set the judge off. She went the hell off, right?
On the basis of hearsay if he's reading from a document.
It's already in evidence, Your Honor. And
okay, when
And Your Honor,
When we were up here at the bench.
so, Your Honor, I'll ask additional questions that I think will,
Sustained.
okay. So, after seeing this
Your Honor,
number,
I have a motion, please. May
I got
we
a
step up?
motion. I got a
Yeah.
motion.
My motion is a motion for mistrial, based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. The state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting. This is who it belongs to. So that was my objection. I believe the objection was well founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
may I respond?
You may.
Judge,
Can somebody put the document up? I don't want to.
yes.
Would you put it up?
First, the state objects to it.
Okay. Can y'all see where it says Stunner Bumpkin right there with that phone number? That is the thing in question right here. Right? That's doo-wop typing Stunner Bumpkin and here's a phone number, right? Pretty much saying this is my number, call me. Right? This is what they're arguing about right now. Because that's hearsay. Because they don't know who put that up there.
A mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with where's the phone number? There it is.
Yeah,
Okay.
the comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor,
to testify to that?
I'm asking him, and I understand the court, I'm asking him what handle it's next to, and Your Honor, what he did after seeing what he saw on this social media page.
You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper, and so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Okay, before we continue, if y'all remember, for the people that been here, this exact thing happened under Glanville. They went up to the front because there was a video that they were arguing about, a 7-second video. According to Attorney Love, only one voice is in the video, and it's Young Thug's voice. There's no other talking. There's no other there's no other voices in the video. The defense said, yes, there is. Love told the judge, they are lying, judge. There's no more voices. It's only Young Thug's voice. The judge took Love's word for it, and they overruled the defense's objection. As soon as they all got back to their table and they got a chance to review it, because you got to remember, The defense they didn't agree with Love, but they just took her word for it. They like, okay, maybe we was confused about it. And then they went back to their tables and it came back later and said, Judge, we got a motion. Love told you that there was no more voices on that video. There's like 7 voices on that video. And she lied. And then she said, pretty much saying, I didn't know I lied. I didn't mean to say that. I didn't realize there was other voices. I thought there was only one voice. I was mistaken. It's the exact same thing. She went up to the bench, lied to the judge, got the judge to overrule some objections, and then went back and did the complete opposite, and it was a complete lie. So Miss Whitaker is not handling it like this is the second time because this is her first time seeing it, but Love has done this before. This is her game. This is how she play. This is how she get down, right? So let's get back to it.
Your Honor, it explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because this is legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The entire cross
number with the comments.
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally asked that.
I asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there and I asked for everything that was on the right side, all of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse. It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what it is. If it's disingenuous, if it is that. I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, But honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes.
I'm going to take a break.
I'll have a ruling when I get back.
God, you stressing me out. Because look, y'all know why Whitaker is really mad and stressed out? Y'all know why Whitaker is mad and stressed out about this, right? Because Whitaker would have been thrown this case out. There's people higher up than her telling her she can't. So every time Love do something ridiculous, I don't watch this clip so many times because it was so wild. Like it was some bars in there. You know how much Whitaker wants to throw this out? She went in the back, called Glanville and said, Glanville, come on, man. You got to, come on, pull the trigger on this. Let me get rid of this case. She probably called Fonnie Willis. Come on, do you see what's happening right now? This lady is out of her mind. What are we doing here? And they probably told her, listen, she does look bad. It is not a good look. But the thing that they're arguing about right now is not consequential to this case. It's not exculpatory for anybody. It's not inculpatory for anybody. It only had a phone number and a conversation about a phone number. You can just exclude the evidence. Don't let her use the picture. And that's as far as we go. If she does anything worse, if we continue to see this, then we'll pull the trigger. We'll let you call a mistrial. Because y'all notice that she does not, when there's a heavy mistrial motion like this one, she always needs to go in the back and take a break, right? Y'all realize she's going to call them people above her. Y'all know that when Glanville was the judge, Glanville didn't have to consult with nobody. He was the top guy. So Glanville could have just did what he wanted. He just didn't want to. Now these judges that are under Glanville, and he's not their boss, but he's the chief judge in Fulton County, right? So I think, now this is me, alleged, I think she's going in the back and calling people. And I think they're telling her that wasn't that bad. Just yell at her in court and let it go, right? So that's why Whitaker seems to get more and more brutal. I'm saying brutal, more and more insulting to Love as Love keeps on doing this stuff. Because I think Love is looking at Whitaker. I think Whitaker is looking at Love like Love is making her look bad. If I'm Whitaker, the fact that I keep letting you do this stuff in front of me and I'm not throwing this case out makes me look bad. And I think Whitaker is getting more and more frustrated at the fact of she's looking crazy too. Her name is in the news also with this. You got people all over the internet slandering her also. She's an elected official. How she looks in this case can also impact whether or not she gets reelected at some point. She doesn't have to worry about anything right now because she's not, these judges run unopposed all the time. But at some point, people are going to say, oh, that's that Whitaker lady that let Miss Love get away with a bunch of craziness. So we definitely not going to, so that's why I think Whitaker is really on her head like that. You understand what I'm saying? And so then she goes, makes her calls and she comes back and she has clearly cooled down. And when she cools down, it kind of gives us as viewers the appearance that, okay, Whitaker is just selling wolf tickets. She's just putting on a show. She's doing all the talking, but at the end of the day, she's letting Love get away with it because she didn't call a mistrial. That's how it appears, but I do think that somebody's stopping her from calling a mistrial. There's no way she's not calling a mistrial. Somebody's stopping her for sure. Let's get to it.
All right, I'm going to deny the motion for mistrial. It's not as if the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal. But I am going to exclude that statement and just tell the jury to disregard the statement and any testimony that had anything to do with the statement.
Your Honor, this is.
Let me show y'all. We got to read body language a little bit. Yeah, if y'all don't mind, I'm not a psychologist, but I've studied. Okay, let's look at Whitaker's body language. Now we've been watching Whitaker for a good 2 months now, so we have our frontal lobe is firing on all cylinders, right? We have our own internal machine learning, and we have downloaded the data on Whitaker's normal body language, right? Let's watch her right here. Now, this is why I think that she definitely went in the back, called somebody, and they said no. Watch her.
Not as if the state couldn't have gotten the testimony in an appropriate way anyway.
Fidgeting.
It's not like the testimony itself is that big of a deal.
Opening water bottles and closing them right
But
back.
I am going to,
Fidgeting. Scratching her nose.
I'm going to exclude
Stuttering.
that statement and just
with her
tell the
face.
jury to disregard the statement
Look at
and
the
any
pen. Watch the pen
testimony
work that she
that
does.
had anything to do with the statement.
You see this? All this fidgeting?
Your Honor,
This is-
this
this
is
is
from
the-
United States versus.
This is the body language of somebody. This is the body language of a person who wants to do something, but they cannot do it because of something greater at play, and they can't override whatever's happening. Whitaker is calm as hell. Whitaker's demeanor is always stoic. Whitaker is very black and white, zeros and ones. If that's appropriate evidence, it's in. If it's inappropriate, it's out. I'm not hearing nothing else. Whitaker is I made my decision, it's over. Whitaker never fidgets with anything. She playing with her face. She playing with the pen. She's opening water bottles and closing them back up without taking drinks. This is the body language of a person who's handcuffed and cannot make the decisions that they want to make. All right, let's get with the Brian Steele. You know Brian Steele is going to come with some cases. You know Brian Steele is going to tell you about how, Brian Steele is going to let you. Yeah, look at Max Shard's face right there. Shard is just disgusted. Max Shard is disgusted. If they can prove that she called someone and was told no, wouldn't that create I see that Juice said, good question, D, so I just read it. And I'll get back to the rest of the chat later, but I saw a good question. If they can prove that she called someone and was told no, wouldn't that create a mistrial by default? No, because that's something they would never be able to prove. So that would be something I guess you could come back for, like an appeal or something. But how would you ever get that type of evidence, right? But let's get what Brian Steele is going to throw some case law to show, like, hey, judge, if a prosecutor keeps on doing prosecutorial misconduct, you got to throw the case out anyway. But let's get to it.
Roberts, Roberts. It's 640F2nd 255. It's the Ninth Circuit, 1981. It's been cited many times. It specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know
I want this. I got another. It's like another 2.5, 3 minutes, right? I want everybody to pay close attention to these clips that's about to play right here, because Brian Steele and Whitaker. Now, this is like OG defense lawyer, Brian Steele, talking to OG prosecutor, Whitaker. Whitaker's a judge now, but she was a prosecutor for a long time. They are having this conversation. This is like a backroom type of conversation that they're having in front of Love's face, pretty much like determining or discussing the fate of Love's case future in front of her, like she's not even there, like she's still in law school or something like that. Like, just listen to how they are talking about her in front of her. It's just kind of crazy. Oh, snap.
you got my motion.
I know, and I know what your argument is. Here's the thing is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway.
She wouldn't be able to try the case over again anyway. Important to note here.
So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial? anyway, based on that. Yes, potentially we get to that point at some point. But there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
I don't know. I don't know what they think, but
Try the case because they think they're losing the case. I think they think they're winning the case.
I think they think they're winning the case. Whitaker is done with Love. She's had enough. She said in front of the world, I think they think they're winning the case. Jesus Louises.
I don't know. I don't know what they think, but I will say this.
Oh, is that in the know, Miss L.J. Hall? Miss L.J. Hall is the one that that civil rights lady told on the other day. How you doing, Miss Hall? Yeah, I was on your side the whole time before they came back with any explanation, because I sat in the courtroom behind you one day and I was like, that lady's cameras are too nice for that picture. So I said it from the beginning. Shout out to Miss Hall in the building. I appreciate whoever told her to come check the video out. Yeah, they was tripping trying to throw you under the bus like that for sure. Let's listen to what Brian Steele is about to say.
I don't know. I don't know what they think, but I will say this. This is not becoming, in the state of Georgia, of a trial. And it is all the time, Your Honor. It is all the time. At some point, it's got to end. Because this is not fair to Mr. Williams, and I assume the other people on trial will agree. It is this constant hiding laws, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing with the court. And I think that it does rise to a level now, but I understand what you rule. But I think that we're well beyond it. And the reason I said promote these things is it's literally from the
Oh, I saw that. I know. I mean, I think my frustration was apparent a few minutes ago. But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team. Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate. But at this point, and we're going to just move on with that exhibit being excluded. I don't know if I can stress any more than I already have how much the state's lawyers need to make an effort to be upfront and forthright in the trial of this case. So let's get the witness back in.
Hey, one thing I will say, Miss Love has some thick skin. She got some thick skin. I see what Esquire just said. She's not listening. I don't think she can listen. If you had to listen, because Love is in here doing such crazy stuff, if she actually listened to what people were saying, she would be in need of antidepressants day in and day out, because she got to have some thick skin for this job that she's doing and for the type of work she. First of all, what do y'all think Hilton is thinking? Because Woody put Hilton through hell, right? Since June 7th, when Woody first showed up, until like August, whatever, 10th when he got off the stand, or whenever he got off the stand, like from June 7th till a couple months later, Hilton had to go through the ringer, right? Dealing with him just as a witness, period. And I didn't think it could get worse than that, but Love is just like raising the bar for how bad a person can get at prosecuting a case. Like she's putting it so far like out of reach that this is gonna go down in like the Hall of Fame as like some of the worst prosecuting that we've seen. And it's kind of crazy.